by the way. Because I'm happy. Clap along if you feel like a room without a roof. Because I'm happy. Clap along if you feel like happiness is the truth. Because I'm happy. Clap along if you know what happiness is to you. Because I'm happy. Clap along if you feel like that's what you want to do. Here come bad news talking this and that. Friends to you, don't waste your time. Here's why. Because I'm happy. Clap along if you feel like a room without a roof. Because I'm happy. Clap along if you feel like happiness is the truth. Because I'm happy. Clap along if you know what happiness is to you. Because I'm happy. Clap along if you feel like that's what you want to do. Hey, go! Bring me down, can't nothing bring me down. The love is too high, bring me down, can't nothing bring me down. I said, take it down, bring me down, can't nothing bring me down. The love is too high, bring me down, can't nothing bring me down. I said, clap along if you feel like a room without a roof. Clap along if you feel.
Good morning, good afternoon, good evening to all our participants in this particular webinar. My name is David Roberts and I'm the Global Director of Payments for the GPS series of events, Global Payment Summits from Currency Research. Today we're going to focus on a very different issue from our previous webinars. So we're looking at crypto asset regulation and the results of a new consultation process that the European Commission initiated some months back, which has a bearing on very many of the operators here in Europe. I'd like to welcome our panelists. First of all, Patricia Risso of Bitso, Stefan Leloup, Max Bohnen of B2C2, and our moderator Monica Monaco of Trust EU Affairs. We're also expecting Jan Seysens from the European. Had a few issues of a technical nature getting on board, but we hope to welcome him very shortly. For those of you attending as delegates, you'll notice at the bottom of the screen we have a Q&A function. So if you'd like to ask any questions about what is being discussed today, please click on that and put your questions in there. We'll endeavor to get to those questions. If not, then we'll try and ask them to the panelists following the debate today. We have an hour and 15 minutes, so an hour of debate and 15 minutes of questions. So let's kick things off, and I'd like to hand over to our expert moderator, Monica Monaco of Trust EU Affairs. Over to you, Monica.
Thank you, David. So welcome everyone to this webinar. My name is Monica Monaco. I am the founder and managing director of Trust EU Affairs. We are a consultancy here in Brussels. We work on financial services and payments. And I've been involved now a long time on crypto. So for me, this file is extremely interesting. I run a working group called Blockchain and Virtual Currencies Working Group, and we are consistently working on this matter. So it's my pleasure to introduce the matter today and to present briefly our speakers. So I would ask, first of all, before we go to the content of the webinar, I would ask my speakers to present them very briefly. So I will start with Patricia. Patricia, welcome. Patricia Risso is the head of regulatory risk for Bitso. Patricia, can you explain a bit to our audience what do you do as work at Bitso, and what do you think about this subject?
Okay. Firstly, I'm Patricia Risso from Bitso. Bitso is a Gibraltar company, and we are licensed and regulated to carry out crypto assets, and we're an exchange. We've had a license for a year, and today is actually our first anniversary, which I'm happy to say, of actually being
happy anniversary
and licensed institution. And I double up because it's my birthday as well. So, and I'm currently, attending this panel. I'm quite enthusiastic to give you my views from an ecosystem, a space which is already abiding by MLD5, and not only that, 9 core principles were principles-based, not rules-based, which allows this ecosystem to develop. And one of the things that our regulators in Gibraltar are very conscious of is to make sure that we don't stifle innovation, and also give us that ability to project ourselves in a very different manner to our third-party providers, ongoing partners, for example, banks and other financial services institutions, like the insurance space as well. So yeah, that's me in a nutshell.
Welcome, Patricia. Stefan Lelou. Stefan is welcome to the webinar. Stefan is Managing Director of Bitstamp Europe and also Compliance Director. Over to you, Stefan.
Thank you very much, and good day, good morning, good afternoon, good evening, everybody. Thank you for being here. So I'm Stefan Lelou. So I'm one of the authorized managers of Bitstamp Europe SA. So Bitstamp Europe SA is a regulated entity. We are a payment institution. We got the license like 4 years ago in Luxembourg. We passport the license throughout Europe. We have a presence as well in the US. And our company is mainly based in Slovenia as well, where we have a lot of resources. And I'm also working as a consultant for the FATF, the Financial Task Force Against Money Laundering, as well as Europol as a consultant again. I'm delighted today to give you some outlook regarding this, the implementation of the anti-money laundering regime, the perception of cryptocurrencies in Europe from different actors. So hello everybody again.
Thank you, Stefan. Welcome to our webinar. And then I would like to present Maxime Boonen. Maxime is founder of B2C2. Maxime, if you can just please introduce a bit yourself and what is your interest in the European regulation in general.
Yeah, thank you very much, Monica. B2C2 is one of the main trading firms of the digital asset markets. We provide market access to an institutional client franchise. We started in 2015, and we were the first company in the EU to receive a MiFID investment firm license through our UK subsidiary. And I'm interested in the discussion here because obviously as a EU regulated institution, this is something that is front and center for us. We also have, beyond our headquarters in London, we have an office in the US and one in Japan.
Thank you very much, Maxime. So my panel is now completed with Mr. Ian Saintsens. Thanks for joining us. Ian works for the European Commission. He's head of unit in DG FISMA. FISMA is the part of the Commission working on financial services regulation, and he's head of unit of B5 unit, which is working on digital finance. Ian, welcome to our webinar. If you can just in a couple of words explain what you do at the Commission, which are your responsibilities, and then I will start presenting a bit of the content, and then we can go on the content discussion.
Yeah, thank you very much, Monica. Thanks for the invitation, and very happy to discuss with you today. Looking forward. We are at the European Commission. We are a team, actually a new team since the beginning of this year, since the beginning of this Commission, still before the COVID situation, but more important since then, who are looking indeed at digital finance. And let's say all the different questions, how we can support, but also how one needs to regulate indeed the digital transformation of the financial sector, which is something specific to finance, but also a very cross-cutting issue across many other sectors. So we are also coordinating that with our colleagues in other parts of the European Commission, whether they're from DG Connect, whether from DG Competition and DG Just. So many other aspects which are affected by that. And as part of our work, indeed, right now, we are preparing a new strategy for digital finance in Europe, which we should publish after the summer. So this discussion comes very timely for us as well. Thank you.
Thank you very much. So just going back to our matter here. So the idea of this webinar was to discuss crypto asset regulation. So why we want to discuss this now? If I may recap very briefly, so where we are today. So this was in 2018, there was a FinTech Action Plan published by the European Commission that included also mandates for the European supervisory authorities for them to provide reports and advice of the applicability of current European regulation to crypto assets. This advice prices were published in 2019. Then the European Commission started a consultation on possible regulation of crypto assets in the spring. This consultation is now just closed. So our idea is today to try and understand which type of framework we could have in place for crypto assets in Europe, and which are the possibilities for this let's say regulation or legislative framework to appear, both in terms of timing and content. Coming from myself from this area, because I work a lot on crypto regulation, for me the discussion is really about how crypto assets could be divided in types, and also, you know, are we talking about crypto assets used for payment, crypto assets used for investment, crypto assets used as utility, what the Commission thinks. So my first question would be for Ian to say, first of all, thanks for sharing your knowledge with us. And we don't want to reveal any secrets during the webinar, but we would like to have some information as much as possible on what is the Commission planning, which is eventually the schedule, and which are also the hurdles, because this would be, if there is a legislative proposal to cover crypto assets, this would be the first time under European law. The only case in which crypto assets are under European law for the moment, and that's only for virtual currencies. It's in the scope of the 5th Anti-Money Laundering Directive, but there is nothing else in AML law for the moment about the virtual assets. So Ian, what can you share with us today about this matter?
Oh, thanks very much. Indeed, I think we have received, let's say, an overwhelming, let's say, feedback to the public consultation which we had done earlier in the year. With a lot of interesting, let's say, aspects and food for thought. I think we know, maybe we have, I myself am not a real expert, but we have some people who know this market pretty well, but I think we've all learned still quite a bit more about it. And we've all probably also seen that what we learned today about it may not be true anymore tomorrow, because it is really in rapid evolution. But I think we also see it clearly that indeed a regulatory framework is basically is the next step, which is necessary actually for this market to further develop. Because I think whatever area you look at in crypto assets, I think there have been interesting developments and important ones. But the legal uncertainty has hampered quite a bit of the development. I think also in finance, and that's maybe where the finance is different from other areas where DLT is used. Finance is a risky business, so people would, at least mainstream people would put their money, would get financing only from sources where they know that the risks are kept in check and they're properly regulated. And in that sense, basically, for this sector of the use of DLT in the financial sector for crypto assets to further grow, indeed, legal certainty across the EU is needed. Now, from our side, we are, as I mentioned, we have evaluated the response to the public consultation, and we are indeed now preparing, let's say, a legislative proposal, which I think we would normally issue in the month of September, so just after the summer break. And then, of course, as you know, in the European Union, basically, this proposal will have to be discussed by the Council of Ministers. So all the 27 now member states and the European Parliament before it indeed becomes law. So that's in a way the timetable and the direction of travel we're working at. I think when we look at the responses to the public consultation, it is also, and our analysis, it is also clear that a part of this universe of crypto assets actually is covered by the existing legislation. So part of it is regulated space. And then the question is basically, first of all, where do you draw the line between regulated and unregulated? And second, basically, does our regulation include some kind of obstacles for it? So that's, I think, one work stream, but we would confirm, I mean, we are not on a track where we would say crypto assets, well, just because they have crypto in their name, basically, they should be treated differently from other instruments which have the same economic function. I mean, if something is a financial instrument, there's a reason why certain rules apply, and that is the case whether it's a crypto financial instrument or a more traditional one. So in principle, in that sense, in this area, we have rules which are there, but then we have to see indeed, and that's something we're working on, to what extent, let's say, there can be some flexibility in the application of some of the rules, because not all of them would indeed fit in a DLT context. I mean, just to give one example, in let's say trading and settlement chains, which are much condensed, indeed, not all the rules which we're having today fit in the exactly same way then they would fit in a traditional context. That is, I think, one of the key issues we got from the public consultation. So, I mean, as Mr. Dombrovskis has also said, we are thinking about some kind of experimental pilot regime in this area for those crypto assets covered by our legislation, not to do sweeping changes and to carve out people from our rules, but to basically see that we have some room for experimentation for smaller projects, indeed, to let them grow. And then, of course, for those crypto assets which are not covered by the existing rules, we are considering indeed a new framework which would have harmonized rules and also then have the possibility of passporting in the EU. I think I would leave it to that for now, because I've already spoken too long.
Yeah, I think this is very useful. Thank you very much. So if I understand it correctly, whatever the Commission is going to publish will be a mix of some form of pilot regime and also some form of regulatory framework. Depending on whether these crypto assets are already covered in principle under European law or not. This is interesting. I mean, it brings to the discussion about securities, for example, and whether, you know, the definition of securities should be updated in order to cover crypto assets that are used for investment purposes. I've been looking at this for some of my clients, and what we see is that securities are defined under national law differently in each member state. And so we see a difficulty, for example, if we had to put crypto assets under MiFID II, simply because there is no definition of securities under MiFID II per se, so it would be member state level. So that's very interesting, and thank you for sharing this with us. I would like to have reactions on this from my panelists. So, for example, Stefan, as you were saying, you are very active as Bitstamp around the world and also in the US. My first question would be to you about what is your experience in terms of alignment and also differences between, for example, the US and the EU when we come to regulation. Which are the aspects you see? What do you see in terms of differences, in terms of approach?
What we see is that, well, understanding is that the EU is trying to to set up a regulatory framework that is applicable to virtual assets. The US is doing the same, but in a different way, in the sense that I'm not always sure that the EU and the US would be coordinating the efforts and the perception of virtual assets to have some kind of common regime. Well, is it a goal ultimately? I don't know. We can debate that. But there is a difference in perception in the two regimes. Let's take, for instance, the level of the prevention of money laundering, for instance. There are, especially on the travel rule, there are a different practice in the US compared to the practice that is applicable in the EU when it comes to travel rule. So there are some differences, but the key, I would say, the key things is, and maybe we can come back to that, is the perception of the industry, meaning the customers, the banks, the regulators. That's something that is key. And here, regardless it is the US or the EU, I would say the perception, and if we have time, I can elaborate on that. The perception, what the obstacles are more or less similar.
Okay, thank you very much. Patricia, would you like to add something on that, being in the position where you are and
yeah.
looking?
And from one of the things that sets us apart and BITSO when carrying out a jurisdictional analysis where we're going to get regulated and effectively licensed was back in 2008, the Gibraltar jurisdiction. I have to say that now we're in a Brexit scenario, but we rolled out a DLT framework capturing distribution ledger companies that actually could be in scope. And we decided to go through a route of creating this particular framework with 9 overarching principles capturing anti-money laundering, corporate governance, and so forth. So we mimic a financial services institution. Now, one thing, just going back to the European and US level and the nuances and the differences that we have, one of the things that we would like to see from the European Union to be able to passport and effectively create a level playing field is also setting the global standard. So, you know, it should be far more reaching in ensuring that the European Union sets that standard and we could follow from a crypto asset point of view. Not only that, one of the things that, and I'm really happy that Jan is here, is that, and it's a critical point as well, is that sometimes virtual assets, not necessarily crypto, virtual assets do not fit in certain traditional directives. For example, e-money, it can be MiFID II as well, and the Payment Services Directive. So we have directives that were written at the time and without virtual assets in mind. So creating a DLT framework is extremely important. I'm not going to argue with certain, investments with underlying crypto shouldn't be, captured by MiFID II, for example. But there are a lot of unanswered questions if you have a DLT framework. And that investment is crypto to crypto, and there's no fiat interaction. Should it be classed as MiFID II? So this is a very, and we have very little time, and I would like to have all these discussions. But in terms of what the European could do and pilot is actually to look at those traditional directives. And one thing that we've got to be conscious of is not to stifle innovation, and we have the room for maneuver to grow this ecosystem, and that's so important as well. Not only that, assessing how we're going to treat stablecoins, which is the biggest, hot potato at the moment, obviously because of the global stablecoins and the likes of Libra that have brought it to our attention. And there's a lot of focus on this now, whether it is because if it's a fiat underlying currency on the stablecoin, should it be classed as fiat? And that is it. So there are all these discussions, but let's not forget that these traditional old directives, not old, they're not terribly old, but where we come from in crypto, a year is old. So you can imagine that you need something that's versatile and can change very quickly. And that's why I suppose Gibraltar went down the principles route, to be able to have that level of growth and evolvement within the ecosystem. Thanks.
Thank you. That's very interesting. And then the stable coins, I would like to ask a question on Ian in a second on that one. But before that, Maxime, we were also discussing about passporting. So Ian has been saying that they may build some form of passporting regime. Maybe this could be part of the proposal of the Commission. As also B2C2 is present in different parts of the world. What do you think, and it's active in Europe, what do you think about this idea of passporting? What about passporting?
Yes, it's quite interesting. I want to touch upon something that Stefan said. It would be useful to have regulatory alignment. Sometimes it is the case. Not long ago, we were able to passport our EU license into Canada for some of the products that we offer. Usually we think of passporting as something within the EU, but it was nice to have a fast track in Canada. Now the problem is that globally speaking, you've got countries where, and I'm not talking small countries, major jurisdictions, where one thing is legal or doesn't require a license in one jurisdiction, but something else is the opposite. And in another country, it's flipped. So it's difficult to navigate, not so much because intellectually it's complicated, but just, it adds to the regulatory cost that we need to support, when really, I think for most crypto companies, our operation, generally speaking, are going to follow best practices. So it's not because we have a license in one country and no license in another country that we're not going to abide to the same principle at the group level. So it would be nice to have that regulatory alignment, because if you project yourself in the future, we're going to have in crypto all of the services that we're used to in conventional markets. It's clearinghouses, exchanges, custodians, anything that exists in conventional markets, you have to believe that it's also going to exist in crypto. And the thing is that it's not, I think that the regime in the EU philosophically is good and it works, and it would perfectly, philosophically, it could apply to crypto assets. But the problem at the moment is that we don't have clarity on whether it applies or not. And so as a group, B2C2, depending on the jurisdiction in which we operate, we have to go after this and that license. We know that the products have to be designed in one way or another, but it would be, for us, frankly speaking, easier if all those, let's say, crypto tokens were deemed to be securities. At least we would know where we stand. And I don't think that the framework in the EU for securities is bad, but we just simply don't know sometimes whether it applies or not. And so I think that there needs to be work done there to cover the gaps.
Yes, I mean, clarity would be essential, and yes, some form of harmonization. I would think everyone in industry could be on that. Jan, going back to these two aspects that were just cited. First, One would be passporting versus national license. What happens in crypto assets and in currency is that there are licenses at the national level who are not necessarily allowing these actors to passport. So you were mentioning between one country and the other in Europe. Despite the national level, these licenses are absolutely regulated and provided to the operators. So you were mentioning, you previously mentioned passporting as something you may look at in this crypto assets regulation or the Commission is building. So first of all, how the Commission perceives now this balance or this equilibrium to be found between passporting between member states and the current existing national licenses. Is something you are going to look at and this how. And the second part of the question coming from Patricia, about the part about stable coins or what are stable coins? Is this something also that will be somehow included under this regulatory framework? I personally think it should, it might, but yeah, I would like to know where is the reflection of the Commission and of your work on these two aspects.
Yeah, thanks very much. I think a lot of interesting points, let's say, raised. Indeed, I think it is the logic of, I mean, if there in Europe, let's say, in the end, if you look back, why is it and how do we justify also towards businesses and citizens that we regulate? It is indeed to create the internal market. And in that sense, I mean, whenever Europe sets up a framework, that framework would normally be relying indeed on the possibility of passporting, of home state control, which I think would be good, and of harmonization, however, of the rules. I think both things belong strongly together. If you don't have clear rules and also partly stringent rules which are acceptable to all member states, then member states will not accept passporting possibilities. I think that is what all those member states which have already, let's say, started on their own to set up regulations, and I think the Maltese rules have been mentioned, have been very clear about. I think risks need to be addressed, rules need to be clear, otherwise, let's say, the internal market won't work. But on that basis, indeed, I think crypto assets is an area where the possibility of passporting has particularly high potential. Then indeed, I think maybe also to come back to one specific point which was made by a couple of intervenants, also by you, Monica, on indeed the difficulties indeed to define, let's say, what is a security, what is a financial instrument. That is indeed something, and the unclarity on that. That is indeed something on which also, let's say, we would see the need based on the public consultation for some further, let's say, supervisory convergence. I am personally not sure that we need, let's say, legislative rules of dozens of pages going into the details of hybrid tokens here and there. I think we need to find the right balance there between, let's say, flexibility over time, because you know that European laws, let's say, take 2 years at least to agree, and then you change them not more than often than every 5 years. So I think that is the right balance to be found between, let's say, a certain level of really hard and fast harmonization, and then indeed, let's say, supervisory convergence on this. We will not overcome the fact that securities notions are completely different in different member states, but I think the crypto specific aspects, talking about hybrid tokens or other matters, I think we can look at. One particular area, indeed, which I hadn't mentioned yet, are the stable coins, which are, I would say, a special kind of animal. Again, to probably large part not covered by the current existing European legislative framework. And in that sense, these would also be indeed covered by the proposals which we are preparing. I think it is clear to everybody that these arrangements, especially when they become more global in nature, would require dedicated rules, maybe also in the light of proportionality, partly more stringent rules, because it's important here to make clear distinctions and look at systemic relevance, risk, and other matters. But within that framework, I mean, very clearly our proposal would also cover indeed stablecoins, and we are now looking still at the details of this. But we hope then indeed also to be able to provide a good framework on which basis also stable coins can be developed in Europe with a good basis. And right last point I wanted to mention on that, we are still debating on the name. Actually, not everybody likes the name of stable coins because it already inherently implies that it is stable. Whereas, well, that exactly depends on, let's say, how you organize them, basically. So, and some member states prefer other terms, but okay, I leave that the debate for another moment.
Okay, that's interesting. This is really a philosophical debate. Now we are looking at. We saw also the Financial Stability Board consultation on stable coins, and we are replying. I mean, the working group I'm chairing is also replying to that. So thank you. This is very useful. I have, if I may, I have a question from the audience for Jan. I would like to take it as it's written very small. I'm going to put my glasses on 1 second just to see exactly what they are going to ask you. So there's a question from the audience coming from Julian Schmucker. Dear Ian, thank you for the presentation. How does the Commission plan to concretely include the guidance findings of the Financial Stability Board, oh, that's what I was talking about, consultation document called Addressing the Regulatory, Supervisory and Oversight Challenges Raised by Global Stablecoin Arrangements? So what does the Commission think about this? I was just mentioning this 2 seconds ago before reading the actual question.
It gives an opportunity to elaborate on that. We are part of the Financial Stability Board work. In that sense, we are also part of that work. And in that sense, also that work is still, let's say, in the process of finalization. But I think you can be reassured that there will be a high degree of convergence among both. I think, I mean, the issues which are addressed in that in the FSB work stream will certainly be addressed in line with those principles also of our framework.
Yes, I mean, thanks for explaining this, because the document is very precise. They are talking about systemic risk, for example, and they are talking about different types of stable coins in function of the volume, and also which will be eventually the attached systemic risk. So of course, you know, depending on whether these stable coins are niche stable coins, or if we are talking about something like Libra, which is potentially enormous, I guess some proportionality approach, as you were mentioning, should apply. So thanks for explaining this. Going back to our panel, Stefan was mentioning earlier something interesting, the perception. So Stefan was saying an important aspect of his work is also, if I understand it correctly, to look at the perception of banks and also governmental bodies of the crypto sector and crypto asset sector. I would be very interested in hearing this. So which kind of perception do you have, and which is your experience in terms of perception of banks and governmental bodies?
So we have a relationship with banks all around the world, as well as institutional customers all around the world, regulators all around the world as well. The perception has slightly evolved in a sense that, and I would speak for Bitstamp, even though we are a regulated company, we are the oldest exchange surviving. We still face from institutional customers and from banks a certain reluctance. It has evolved because in the past, cryptocurrencies, it was a no way, a no go, and that's it. Now, institutional customers and banks, they seem to have adopted a more granular approach, whereby they will look at the different category of risks and ask virtual asset providers how they address those risks, meaning the prevention of money laundering, the market manipulation, which is becoming something that is increasingly in the mind of some customers, the security as well, and the consumer protection. So it has evolved also in the mind of the regulators. They've done their homework, at least in Europe, in the US as well. So they're much more familiar with virtual assets. Enforcement agencies as well. I was discussing with enforcement agencies of huge countries, and they have adopted softwares to monitor the blockchain. They have experts now to do that. So the perception has evolved. But I must say that there is still some blocking points, but not from the business, but from the compliance, legal compliance and risk people. I work in compliance, so I know what I'm talking about. So the resistance, the fear is still there. And I think one of the ways to give some comfort to institutional customers and banks is to have an adequate regulatory framework. Banks want people to play by the rule. People playing by the book, the same book as the one they have to comply with. So sure. If I face a bank, the bank tells me, what regulation do you have to comply with? If I'm telling the bank, well, it's the same as you guys, the bank will be very happy. And that's the reason for which the regulatory framework, development of a meaningful regulatory framework is very important. So it has started with the AMLD5, the prevention of money laundering, that is now applicable to all virtual asset service providers in Europe. So all of them have to adopt a proper KYC, know your customer, prevention of money laundering. The same goes in other jurisdictions, but in Europe, this is it. It's not complete yet. There's still some work to do in terms of harmonization, because sometimes there is only a registration in Europe, sometimes some kind of license, and sometimes nothing at all. So it needs to be looked at. So it's beginning. Now there is another point that would need to be looked at. It's the market manipulations and market abuse, because that's the point that institutional customers and banks are interested to look at. So virtual asset service providers, they have to demonstrate what they do in that respect. Consumer protection as well is something of a big interest for banks. And it's very funny to look at the behavior of banks, because banks behave differently if they are acting as a nominee, meaning if they are acting as representing some other customers and they come to see you as virtual asset service provider, or if they behave like a bank, meaning they will be banking you. And then the expectations are very different if they have to bank you. If they have to represent customers, still expectations very high, but of a different nature. So in a nutshell, it's still important to maintain the discussion, but the regulatory framework, the development of the industry will go through the demonstration that we all play by the same rules as banks do. Hence the importance of adopting a consistent and harmonized regulatory framework for virtual assets.
Yes, I would absolutely agree on that, and it's also in my experience, and absolutely. So what will make the difference is whether you are regulated or not, and how. And we've been seeing in Brussels many position papers about this consultation the Commission ran in the spring, and it's interesting to see that also banks are asking for regulation of.
If I may interject, it goes beyond if you are regulated or not, because now the question is, okay, if you are not regulated, well, the banks, they will say, well, no way, they don't want to discuss with you. But now the discussion is, how are you regulated? And are you playing by the same rules as the rules I'm playing as a bank? And how is it enforced? Are you audited, for instance? That's a critical point.
Yes, it becomes a consideration of level of risk. So absolutely, it's absolutely a critical point. Absolutely. So, Patricia, do you have anything to add on this? Because I see you from your face, you're interested in the matter. So
I am very interested, because the experience of being regulated and licensed does open a lot of doors. And when you can say that you're audited, and you have, because we have to abide by certain corporate governance rules, very similar to banks in terms of statutory regulatory capital, how we maintain liquidity. And those are the salient points and it resonates with me, Stefan, what you're saying, because the bank will look at us like they look at themselves, and we should abide by the same rules, which we do. And one of the things that I suppose that BITSO has been on a mission to, apart from, supporting the FATF and other international organizations that set standards, it's important that we don't forget that it's about education. And one thing that I realized by going to visit certain service providers, not only banks, but insurance companies, because we have to safeguard the assets of our clients. This is the consumer protection or customer care point that you were making, and I'm glad that you made that point. This is one of the things that we've been lobbying and working with is the insurance companies. We want to be insured, we want to safeguard our assets, that we have the ability of acquiring insurance like any other financial services provider from a fraud, a cyber security perspective and so forth. Now, that's been a very, very painful exercise, but something that we have actually, this space is evolving, and because they're being able to quantify those risks, we're getting insurance now in the marketplace. Now, one of the things is that what this brings, and the point back, what Stefan, and I think that Stefan agrees with me, is like having a common and a level playing field is key in this factor, because everybody will have to abide, and I wouldn't like to call them rules, especially in this ecosystem, principles that can evolve. The rules are very hard and very traditional, and it's a term that I don't particularly like using. So principles that we could all set for the industry that they abide by, and something that the banks and other financial services providers, because it's not purely about banks, there are many other third-party partners that we have to use that facilitate and assist this ecosystem, that they can have that assurity that we're abiding by certain standards. Now, the doors have been opening, and last year was a struggle, but this year we're seeing a totally different, acceptance of cryptocurrency. There are banks purposely marketing themselves as crypto friendly, which is great, because they're understanding the space, and they understand that now, and I can see it even with a lot of stable coins and initiatives, and China making noises about having their own digitized currency and stuff like that, that there's a fear of missing out. So this is something that Europe and the European Union has to be conscious of, because by setting all these standards and hurrying up, 5 to 10 years of drafting a directive is too slow in this space. So, it's putting your roller skates on, sorry, Jan, but you're here. And I might as well take the opportunity in that this needs to be rolled out, because there is an urgency. There is an urgency to take care of that underlying customer. Let's not forget that the banks made a lot of mistakes, and they transitioned and evolved in all the directives and all the regulations that came out of the EBA and ESMA. They've gone through that process. Now we want to go through that process, but we need to catch up and demonstrate that we're an industry on our own right, and we require a set of regulations and laws that fits the ecosystem. Sorry. Thank you.
Thank you, Patricia. Ian, can I have your reaction to this? What does this whole story of access to banks and perception from banks is something the Commission is going to take in consideration?
I mean, I think as Stefan said it, I think it's not. I mean, we cannot. It's not us to change the perception of banks, and it's not our. I mean, it's the banks who do the business basically. So it's not our job to basically change that or to order a change of that. I think what we can do is indeed to make sure that there's a regulatory framework in place. So, and that would then give the banks the comfort to basically change perceptions. I think it's as easy as that basically.
Yes, in terms of, thank you, Jan, in terms of legal qualification of crypto assets and how they are qualified under national law, and then how eventually crypto assets will be divided into categories, where is the reflection of the Commission on this? Because we've seen a lot of definitions at national level that may differ one from the other. The local qualifications of legal qualifications at national level of crypto assets may vary. I understand the Commission is thinking about 3 different types of crypto assets, so depending on how they're used. So this could be, again, used for payments, used for investment, used for utility. How are you thinking of harmonizing all these notions of crypto assets, knowing that at national level there are already some legal qualifications of crypto assets under national laws in some member states?
Yeah, I think from our side, indeed, you can have long and very interesting discussions about the details of, let's say, the distinction between different types of crypto assets. Again, I'm not sure that, let's say, beyond what is strictly necessary, I mean, the legislator or the regulator is best placed actually to kind of find different business models or categorize different types of businesses. I think what the only thing we need to do is to see, well, where do we think different rules should apply to different types of animals? And then, of course, you need to distinguish, and that's where you basically then also need to define. So I think one practical example, which I mentioned before, is indeed, let's say, the question: what is a financial instrument? Was not very clear. If you're a financial instrument, you are covered by MiFID. If you are not, then you are not. And in that sense, of course, we need to flesh out what it means for a specific crypto asset indeed to be a financial instrument. But we will not make a detailed, let's say, taxonomy of this, let's say, to the extent that things will not be covered by similar rules. I think another distinction certainly which needs to be made is with stable coins. I think we discussed that before. But again, I mean, I think we try to keep it as simple as possible, and that allows them the market within those kind of broader regulatory categories to develop many kind of sub names, subcategories, sub labels as the market wants to. Basically.
So this would mean, for example, if I understand it correctly, so if a crypto asset is used for payment function, does this mean this will be under the PSD2 or PSD3 or follow up to PSD2?
Well, I think there the same principle would apply as for in the other areas. Basically, if you meet, in spite or even though being crypto, if you meet the definitions of those areas, then indeed you are a respective service. But I mean, the payment service, then you have to go into a bit into the detail. I mean, you have the e-money directive, which regulates the issuer, and e-money, I think, is defined very clearly.
Issued on receipt of funds. It's defined as issued on receipt of funds, so prepaid. And
then you have basically that. So I think that is basically what is the most. Then you have the Payment Service Directive, which is, however, less about the issuer, but maybe indeed more about those who are providing services indeed. So I think, in principle, I mean, the rule is the principle would also be that one basically. If you are covered by the existing rules, that's would stay the case, yeah. Indeed.
Yeah, I'm asking this question because when working on the 5th Anti-Money Laundering Directive, we were looking at the definition of virtual currencies under the 5th Anti-Money Laundering Directive, and virtual currencies are there defined as a mean of exchange that can be used for a number of aims, including the aim of payment. So I'm just wondering, you know, if under the 5th AML, virtual currencies are also to be used as a mean of payment, then mean of payments are regulated under PSD2. And so this is why I'm trying to understand how this would work together. And also you were mentioning in the beginning of your presentation, a pilot regime. You said this could be a combination of a pilot regime plus a legal framework. What is a pilot regime? Would this be like the 28th or 29th regime, or would this be a temporary regime? What exactly are we talking about when we talk about pilot regime? An experiment of some sort, a legal legislative experiment of some sort, or?
Yes, I mean, okay, we are working on the details, so I don't want to go much more into details. But as a matter of principle, indeed, it would be. So we are not looking at. Don't worry, we're not looking at 28 regimes or other things. But I mean, we're looking at something which basically would allow you, in certain circumstances, if that is indispensable for, let's say, DLT-based assets to work under existing rules, to basically have some flexibility on how those rules are applied and implemented, basically. So I think that's a bit the idea. Now, I mean, some refer more to it like an experimental, some experimental rules or pilot rules. You can see that how you want. Indeed, the idea is to gain a bit of also regulatory experience with DLT regulation. Actually, that's a bit the idea. Okay. So not to jump the gun towards any kind of large whole or changes of our rules, but indeed to gain some experience in a more limited manner.
Okay, so this would be limited in time. So somehow like a pilot regime, I don't know, for 2 or 3 years, or this would be limited in terms of optional, that companies can decide whether to go for it or not.
We're still working on the details, so I have to kind of, say, ask you to have a bit more patience on that.
I'm sorry, I'm curious. I'm trying. I know you're still working on this, but I'm trying because I'm curious. Thank you for it. It's very clear. Maxime, when we talk about this access to banking and possible regulation and you know, equivalence between different regulatory regimes, which are your considerations from your experience? What do you see in terms of issues, in terms of access to banking, and also how this regulatory equivalence between different countries, how does this look to you?
Yes. To answer your question, Monica, I would like to rebound on something that was said that I don't fully agree with. I think that the state as an obligation to try to enforce consumer protection. And at the moment, we see clearly in our market, I think it's one of the elephants in the room, that there's a bifurcated market. On the one hand, you have regulated entities that play by the rules, such as Bitstamp and others. And on the other side, there's entities or maybe even non-entities operating maybe out of the BVI or the Seychelles and places like that. And the problem is that water finds its own level and people want to buy and sell crypto assets. The problem is that if it is not made easy or clear how to act, what the rules are and how to play by the rules, the problem is that the other side of the market, which is unregulated, has been at the same time has grown faster, has attracted more popularity, has been more profitable, and at the same time has not been riskier to run than a regulated business. So when you put all of that together, I don't think that consumer protection, that the authorities are necessarily doing a very good job here by not providing, I would say, a better framework for our companies to operate in. And when I hear that once we put in place a framework, then it is up to the banks to decide if they want to work with crypto companies and the state should not be involved. I tend to personally agree with that, but I think if you push the logic a little bit further, you start getting into problems. I think access to banking has become better for regulated institutions in the crypto market, but there's one thing that is still bad among many others that I want to bring up, and I think there's a big sort of market failure here, and it's auditors. So when you look at auditors, the problem is that there is no obligation for auditors to audit you, just like there's no obligation for the banks to bank you. And I think that the state itself has to intervene from time to time. We saw that in the United Kingdom with the state tried to put together a level playing field when it comes to access to the payment system. And for years and years, the biggest UK banks have provided the smaller banks from having direct access to the FPS payment system, and the state had to intervene. I think that was an outrageous scandal. And I think that we're getting into similar issues now when it comes to audit services. Audit firms have a natural aversion now to working with crypto companies because they don't necessarily understand everything that's going on. And you've got a market failure because an audit normally doesn't cost that much money. So there's no incentive really for the audit firms to work with crypto companies. They can just say no. But the thing is, when you're regulated, you have to be audited. It's an obligation. So what do you do when all the auditors refuse to work with you? And it doesn't matter even how much you're willing to pay. And I think in cases like that, the state has to intervene. And it's not just a problem of the crypto market, although I think that's one of the foremost markets where we have a problem with audit firms, but it's also in quote unquote conventional market. I think what happened with Wirecard is an absolute scandal. The auditors themselves were not compensated sufficiently in terms of doing the audit, and they were making money on through other businesses. That some people are calling for breaking up again consulting versus advisory versus auditing practices. I think we have to start looking at auditing as a public good. I think that we have to consider the possibility that perhaps there should be, a public utility that performs audit, just like, we think that in most European countries, running the train system is a public good and it should be run by the state. I think that even though the system with, banks being private entity and being able to do business as they see fit, auditors being private entities and being able to do business as they see fit, that's worked for, for a couple of decades. But we're getting to a situation where the emergence of new technologies and the fact that we're running on a framework that is, decades old, we're getting into some problems that I'm not sure the free market itself would be able to resolve on its own. And I would like to see some thought leadership from the authorities on that point.
That's very interesting. Ian, which is your immediate reaction to that?
I mean, audit is a complex thing, and we tried to fundamentally overhaul the audit market some years ago. I think we managed only halfway. Many of our attempts were cut down in Council and Parliament. We have tried it, so it's always worth trying again. I mean, on the specific issue which you mentioned now, I would be also interested to understand a bit better, because indeed, I think what we normally hear from the audit market as well, that the big three are basically, foremost, the big four are basically dominating the market and they don't let anybody else in. And there are many companies who are trying to get in, but basically they just don't get to it. So, I mean, given that our laws don't ask you to be audited by the big three, actually, on the contrary, I'm wondering whether that's really more a question, I don't know it, whether there are not other smaller auditors which would be willing to actually work with you. So it's really a question more to understand the issue. I admit I have not heard about it before.
Yeah, I'd like to add a point, like, I suppose lawyers govern themselves, auditors govern themselves as well. So they have their international standards, the IFRS standards. And one of the things that the auditors are saying to us, to be fair to them, and I'm not lobbying for them at all, is that they have no international standards for crypto. So unless they get the IFRS standards, and apparently, it takes a lot of time to draft these standards, then it trickles down and then they're comfortable in auditing. So that is one of the issues that they're having. So this is an international association that sets their own standards. So they need direction and guidelines how to value crypto. So this is the big obstacle, not only for the small firms, for the big four as well, that they need to convene together and set these standards. So it's like a DLT regulatory framework in Europe. Until they have the standards or the regulatory framework, you're pretty much stuck there. And yes, it's about having the appetite to audit. Then they're probably happy to audit your books from a fiat point of view on the revenue generating fiat side, but it's the crypto side that they struggle with. So even if the EU, and I know there've been various attempts, but they self-govern at the end of the day. So, they have to set their standards, and it's up to the crypto community to lobby to ensure that they accelerate this process. Thanks.
Thank you, Patricia. Yes, this is very interesting. And, as Maxime is saying, yes, if you're regulated, then you have to be audited. And what happens then if you can't be audited? What about the supervisory role? What about the supervisors? Is there anything, Jan, that the Commission is foreseeing in the new regulation or regulatory framework for crypto as far as supervision is concerned? Is there a reflection on supervision? Because I remember very well the advice from the three ESAs, from the European supervisory authorities. And so it makes me think, if this was a step before, it makes me think maybe there is a role for supervisor in this. Is there a role of supervisor is something you are looking at when drafting this legislative framework?
Sure. I mean, if there are financial regulation rules in place, somebody needs to enforce them. So in that sense, absolutely. And I think we are looking at the details of that. Still to how this would be fleshed out. From our side, we do also think, I want to clarify that we do think that there is a strong role for public authorities on audit as well. I mean, we do not think that this is only a matter of self-regulation. So I think that's actually arguably, I'm myself German. I think even the half self-regulation which they had in place has not really worked. So I think that is but okay, it is a different topic from the one we have today, basically, I think.
Yes, but when we speak about supervision, this is relevant because, if I understand correctly, the division you were making before, you were basically saying the Commission is looking at two different types of crypto assets, the ones who are financial instruments already under current law, and then the ones which may be outside of existing regulation, but maybe should be covered by ad hoc regulation. So when we are talking about a role for supervisors, are we talking about a role for supervisors on both types of crypto assets or only on the crypto assets that are currently under European law somehow?
Well, I mean, I think supervisors are, today financial instruments are supervised by supervisors. So in that sense,
I know.
But I mean, that I don't really understand then, let's say, yes, we will have to have some supervisors who will be in charge. I think in principle, it's not for us to decide whom member states put in charge of that. That is something which traditionally is governed by each member state themselves, basically, like on MiFID as well. I mean, some different member states have different authorities, whether they basically put things all together in one authority or they have 27 different ones. That is something which goes in the national, let's say.
But there will not be a role for the European supervisory authorities.
I mean, a role, the same thing, we always have roles for the European supervisory authorities because they are there indeed to, let's say, ensure convergence across the board, across the financial sector legislation. So yes, of course, there will be a role for the European supervisory authorities. And indeed, I mean, of course, we're looking at what that exactly would be, but very surely, I mean, for example, I mean, at the very minimum in the area of guidance, for example, on certain interpretive questions of technical standards, etc., this is something which is always foreseen and where we would always rely on the supervisory authorities.
Yes, I'm asking the question because in the framework of our work in the blockchain and virtual currencies working group, we've been reaching out a number of times to EBA and also to ESMA, and the reply also in order to be able to participate in their working groups, typically the one on securities or the one on payments for EBA and the one on securities for ESMA. And every time the reply we received was that they, in their mandate from the European Commission, there was no mentioning of this sector, so they couldn't even have us as part of the discussion because it was not in their mandate this far to deal with us. So this is why I'm asking the question. Okay. Well, this is very clear. Thank you. As I see we are going to be short on time, I would just like to have another round in terms of if you have a wish for this regulatory framework, Stefan, Maxime, and Patricia, what do you think is essential for Ian to retain from this conversation? What is the most important point in your view that the Commission should try and cover under this crypto asset regulation? I'll give you a couple of minutes of each of you because I'm cautious of time. Shall we start from Stefan? Stefan, what if there is one the Commission should retain?
I think that one of the important points, and that was a question I wanted to raise to Jan. I'm curious to know whether you guys from the Commission, before at the stage of the reflection on an upcoming regulation, if you are coordinating anyhow this with other governments like the US, like Canada, for instance, or Japan. That's one of my wishes, actually, is that there is some kind of coordinated approach, a worldwide approach. And I'm very interested to know if you have this, if you share that, and also if you do, and how do you do it? Do you have ongoing discussions with, I don't know, FinCEN when it comes to enforcement, with US Treasury Department, the Japanese FSA, for instance? Is this something that you do to coordinate the efforts worldwide?
Actually, yes. I can very well use this for the apology that I will now need to actually log off and leave, because indeed we have precisely such a meeting with the US, which is starting now at 4 o'clock. So indeed, absolutely, this is. I'm sorry about that. This is happening very much. I mean, let's be realistic. We are not starting from exactly the same rules. I mean, the European securities law and MiFID and US securities law are not exactly the same. So we are not doing exactly the same journey, but I think we're trying to go as much as possible along similar principles, basically.
Okay, if you can be late 2 minutes for your call, just one suggestion from Maxime, one suggestion from Patricia, very quickly, because Jan is busy with the US discussions, but please, if the Commission has to retain something about this discussion today in order to draft this framework, what this would be?
My wish, personally, my hope would be that we can have something that is clear, and then once it's clear, everyone who wants to comply complies, and people who don't want to comply, we start seeing formal warnings and enforcement actions, because it is a little bit disheartening that you're trying to follow a framework that exists. It's imperfect, but you're doing your best to kind of try to fit in the best way that you can. But at the same time, people who don't, there doesn't seem to be any consequences.
That's nice. I would agree 100%. Patricia?
Very quickly, this is a very different ecosystem, and that needs to be taken into consideration, building that DLT framework. We are that different. We don't fit into a traditional regulatory framework anymore. Thanks. Thank you.
Well, thank you very much for your presence, Jan. I don't want to retain you further because you have to have the important discussion with the US. We thank you very much for explaining to us, no secrets, but a lot of information about what can happen in the next couple of months. And we look forward to reading this crypto assets regulation when this is going to be our framework, when this is going to be out in September.
And thanks very much from our side. Thanks, Patricia and Maxime, for your points, which are important ones, and looking forward to continue staying in touch. Thank you. Bye-bye.
Thank you.
Thanks. So shall we try and wrap up the discussion. So my impression is the Commission is willing to discuss with industry, and I think this is already very good. I understand that this crypto asset regulation shall be out somehow in September, and this may be a mix of a pilot regime and also some form of a regulatory framework, dividing virtual assets into at least two categories. So virtual and crypto assets that are already financial instruments, somehow covered under European law, and others which are not at all covered under European law, for which the Commission should try and find a solution. I personally learned a lot today, and I hope it's the same for the panelists from our discussion and from the public. Do you have any final comment for the audience that you would like to share?
Well, I personally, at least, being a European citizen and firmly, with our company headquartered in still today the European Union in London, perhaps it won't last. At least, we're quite happy that we feel like that we're in a jurisdiction where the authorities and the bureaucratic apparatus is at least somewhat rational and is working on principles that we think are sound. When I look at what the European Commission has been able to achieve on issues such as roaming, for instance, on with mobile phones, I think it was a fantastic outcome. And so knowing the principles on which they work, I'm confident and hopeful that they will get to a good framework for digital assets, at least in our regions, yes.
Stefan and Patricia?
I just hope, adding to Maxine, that they do that quickly because they took quite a while with mobile phones. So that is my point, that this is a very fast moving ecosystem space, and we need to be, I think most of the contenders out there want some kind of framework and rules to abide by, so we can have, banking on and off ramps and insurance. So the point is that they need to do it quickly. Waiting for the European Union to set up a framework with a 5-year gap is nonsensical in this space, because we need to take care, we want to take care of our users. So that's how I'd like to wrap up. Thank you.
Thanks.
On my part, I think as much as it is interesting to speak with the EU Commission, it's also good to speak with your local regulator, because they are the ones that are going to put the pressure on the Commission to have to orient the upcoming legislation. So we have the opportunity to speak with multiple regulators. So we advocate for the development of virtual asset service provider regulatory framework in certain directions, with sound regulatory framework. So speak with the Commission is good, but speaking with the local regulator, I'm not saying it's even better, but it's also fundamental to do that.
Yes, doing this job 23 years, I would completely agree. The two discussions have to go on in parallel, so that the two then discuss, knowing which are the concerns of the industry. But I would like to close this webinar. I would like to thank very much my panel. This was very interesting and interactive. I'd like also to thank the audience for watching and for listening to us. And I'll give the word back to David.
Thanks, Monica. Absolutely fascinating debate. Thanks to you all, to Stefan, to Patricia, to Jan, to Max, and especially to Monica for keeping it all to time, and to keeping it, well, to making sure that all the points were covered. This is the latest in a series of webinars. Further information on further webinars will be posted on europeanpaymentsummit.com. So stay in touch, and if you have any further questions, contact me directly and I will pass them on to the panelists. Once again, thanks everybody, and see you at the next one.
Thank you.
Thank you.
Thank you.
For watching.
Thanks
Thank
a lot.
you.
Thank you very much.
Thank you very much.
Bye, Stefan.